This video is to explain to you about the sources of law in Malaysia and specifically on the first type of sources, that is written law. Sources means the legal rules that become the reference for our law in Malaysia. These sources are divided into two kinds. One is historical sources and the other one is legal sources. Generally, the sources of Malaysian law are divided into two. One is written law and the other one is unwritten law, while Islamic law is part of unwritten law. Written law is divided further into three sources: constitution, primary legislation, and subsidiary law. While for the unwritten law, there are four sources altogether: English law, judicial decision, customary law, and Islamic law. Okay, first I would like to explain to you about the first category of sources of law, that is written law. Written laws are the laws which are recognized by the Constitution. They are enacted by the legislatures, which consist of the Yang di-Pertuan Agong, the Parliament, and the state legislative assemblies. These legislative bodies have been empowered by the Constitution to make laws in Malaysia. For the Constitution, it is divided further into two. For the whole federation, we have Federal Constitution. And for each state in Malaysia, they have their own state constitution. With regard to primary legislation, there are three sources altogether. The sources are the Act, Enactment, and Ordinance. As for the subsidiary legislations, they consist of rules, regulations, and bylaws. How to read or mention the provisions provided under those written laws? For the Constitution, we read the provisions as Article 1, Article 2, or Article 3. For the Act, Enactment, and the Ordinance, the provisions are mentioned as Section 1, Section 2, Section 3. And for the subsidiary legislation, we read it as Para 1, Para 2, Para 3. Now we come to the first and highest written law, that is the Constitution. Federal Constitution is the supreme law of the land. By virtue of Article 4, Clause 1 of the Federal Constitution, any other law which is contravened or inconsistent with the provision of the Federal Constitution shall be declared ultra vires and void. The state constitution is similar to the Federal Constitution. However, it is set up by each state and only applicable to the states. The second type of sources for written law is primary legislation. Primary legislations are made by the legislative bodies, which consist of the Parliament and the state legislative assemblies. The Federal Constitution provides that the Parliament has power to make laws for the federal level. As for the state level, the law is enacted by the state legislative assemblies. The primary legislations are divided further into three. They are the Act, Enactment, and Ordinance. An Act is the legislation which was enacted by the Parliament after the Malaysia independence. Enactment is the one which was made by the state legislative assemblies, while Ordinance is the legislation which was made either by the state legislative of Sabah and Sarawak or the one which was made by the Parliament before the independence of Malaysia, or the legislation which was declared during emergency. These are the examples of the ordinances. Now, the third category of sources of law under the written law is subsidiary legislation. Subsidiary legislations are the bylaws or regulations made by the executive bodies, that is, the ministers from various ministries or the local authorities. They have been empowered or been delegated the authority to make the subsidiary legislations by the primary legislations or the parent act. In short, the delegated legislations are made by the relevant authorities in accordance with the parent act. For example, a parent act which was made by the legislature confers power to the relevant authority to make the subsidiary legislation. Here, for example, a minister who has the power to do so makes the subsidiary legislation as required by the Parent Act. And finally, a subsidiary legislation is enacted in the form of rules, regulations, bylaws, etc. This is a further detailed example. For instance, a Parent Act named Educational Institutions Discipline Act 1976, which is also known as Act 174. In this Act, it gives power to the Minister of Education to make regulations relating to the disciplinary matters of the students in the higher educational institutions. And therefore, with that authority, the Minister of Education make the subsidiary legislation as required by the Act 174. For example, on matters relating to the act of copying and cheating during the final examination. As a result, a subsidiary legislation was enacted. Educational Institutions Discipline of Students Rules 1976 was made. In these rules, it provides the punishment for such kind of offences. For example, under the power given by the Minister of Education, with reference to the Educational Institutions Discipline Act 1976, UITM enacted the Academic Regulations 2009. These regulations is concerning the matters on academic rules and regulations for the UITM students. Similarly, under the Parent Act, named Postal Services Act 2012, the Minister of Communications and Multimedia Malaysia authorized the Malaysian Communications and Multimedia Commission, which is also known as MCMC, to make regulations relating to licensing of the postal and courier services in Malaysia. As a result, the Postal Services Licensing Regulations 2015 was made by this commission. It is understood that the subsidiary legislation must not contravene the Parent Act. If it violates the limits of the authority given or inconsistent with the Parent Act, the subsidiary legislation will be void. Therefore, in order to avoid the subsidiary legislation from being contravening the Parent Act, certain mode of controls are necessary. The controls are as follows. Alright, here is the summary for written law.